Good afternoon, my lady.
Good afternoon. I will place the matter on record, my lady. As the court pleases, my lady, this is a matter between the Special Investigating Unit and 4 others. This is Mr. Hassan Ebrahim Kajee, case number GP 22 of 2021, appearing in the Special Tribunal of South Africa before Madam Justice Mudiba, 21 February 2023. My lady.
Thank you. Counsel may place themselves on record.
My lady, my surname is Fouchier, initials GVR, and I appear on behalf of the applicants, the plaintiffs in this matter.
Thank you.
My lady, my name is Manilal, initial A, attorney, and I appear on behalf of the respondent.
Thank you. Mr. Fouchier?
My lady, what is before you today is the application for the irregular step in terms of Uniform Rule 30.
Yes.
That has been unopposed until very recently.
Yes.
I see there is now a belated answering affidavit and a belated practice note filed on behalf of the respondents. I do not know whether your ladyship is going to entertain the answer or the practice note from the respondent, or whether I should just move for the application, my lady. I'm in your ladyship's hands with that. In that,
yeah, I think it's proper to deal with what's transpired this morning, because a link for court was sent timelessly, and none of you appeared this morning.
My lady, I apologize. I was in a consultation and I had no notice of today. The last correspondence I saw from your ladyship is that if your ladyship would require any appearance, then your ladyship will arrange that with the applicant, with a time suitable to the applicant during the week of the 20th to the 24th. So that's unfortunately the last that I saw, and also the last that my leader, Mr. Joubert, saw, my lady. So I apologize that we weren't informed earlier, and he is in court today, and I was in a consultation, so I could not do anything, my lady. So I apologize.
Okay, the registrar is here, so let her assist us. Paul, how did you go about letting the parties know of today's event?
My lady, I did send out a communication on Friday, which Ms. Lydia in their firm, I'm guessing is the assistant attorney, I know they accepted the link. I did send out a communication that the matter is set down.
Did you just send?
I send an email.
Did you let them know
first.
that the matters set down?
Set down for an opposed roll for Tuesday 21st at 10 a.m.
Okay.
That was not communicated to myself and Mr. Joubert. I apologize, my lady. It's clearly a miscommunication. We
don't communicate with you. We communicate with your attorneys.
Yes. And
so the registrar did all that was required to enroll the matter. And I directed her to communicate with Mr. Kajee's, to send that same communication to Mr. Kajee's attorneys, because at that point they had filed a notice of intention to oppose. So what would have happened in a physical court, right? The SIU would have appeared today. Mr. Manilal has, could appear as well in the unopposed court, and the court would direct how the matter should then be heard, should proceed. And that's what I expected would happen this morning.
Clearly, it's a miscommunication between ourselves and our attorneys, my lady, on the applicant side. I can only apologize for that. We weren't aware of the date.
Okay, so the document I have not seen is the practice note you indicate what was filed by Mr. Manilal. I only saw Mr. Kajee's answering affidavit.
So that practice note, I think, was also sent late last evening together with the answering affidavit. I just received it from my attorneys this morning, and only after 10 when this happened, my lady.
Okay, no, that is fine. So what are your instructions, Mr. Fosher?
Well, my lady, I suppose my instruction will still be to move the application as the irregular step, to have the notice of motion and the affidavit purporting to be an exception to be set aside, my lady.
Okay.
I do not know whether there's even an application for a postponement before your ladyship. It's all these belated documents that's just been emailed. I don't know what's been filed. Well, I don't know. It would seem that the practice note is not even filed, my lady. So
yeah, I'll tell you the difficulty that I have with proceeding in that manner is that if you studied Mr. Kajee's answering affidavit, one of the points he takes is that in your notice of motion, you didn't set out his right to oppose. So you didn't indicate by when he's supposed to file at least an opposing and notice of intention to oppose. In terms of our rules, that's the only right you'd afford him in the notice of motion. And at that point, the registrar would then convene a case management meeting where the matter would then be regulated. So he complains of that, right? And obviously, I mean, a judge wouldn't study papers pedantically. So when I directed the registrar that the matter is should be enrolled on the unopposed basis, I had not noted that point. I noted it because it's a point they take in the answering affidavit. And that being the case, I'm not inclined to proceed with this application on an unopposed basis. They've not asked for condonation. And in terms of the tribunal rules, there isn't a basis on which to insist that they ask for condonation, because the date by which they must file a notice of intention to oppose is not indicated in your notice of motion, and subsequently a case management meeting would have been held. All of that has not happened. So I'm inclined to deal with the application on an opposed basis, if you are ready.
yes, my lady, we can proceed on that.
Yeah, I'm inclined to deal with it on an opposed basis, if you are ready. And I'm very concerned that, there are a lot of skirmishes going around, parties taking procedural points, and the matter is really stalling. That's why I would like to deal with, the interlocutories as soon as possible.
Yes, it is.
So that the matter can then be unstuck, and then it does proceed.
100%.
So are you happy to proceed on that?
I'm happy to proceed, my lady. Yes.
Okay.
I had an opportunity to briefly read through the answering affidavit, and I can answer to
you can deal with it.
Yes.
Okay.
Yes.
Mr. Manila, would you like to say anything at this point? Because I've not enrolled the exception. Right. Yes, I didn't enroll the exception, and I don't think it's necessary for me to deal with the reasons why I should enroll it. You will recall that what prompted the Rule 30 application was when the registrar inquired whether the SIU intends opposing your exception, right? So instead of answering to that, they then filed the Rule 31. Perhaps I should tell you why I didn't enroll the exception. In terms of Rule 23, a party is not required to replicate on an exception or to file any further pleading subsequent to an exception. So what would happen under normal circumstances, if an exception is filed, then the next step would be to file heads of argument. There'd be directives to file heads of argument, and the matter is ripe for hearing. And hence, I specifically inquired from them whether they intend opposing it. Had they said no, I would have then enrolled your exception on an unopposed. So I just need you to understand that. So it doesn't seem as if, when it's the SIU, I'm indulging them, and when it's you, I don't indulge you. I follow the rules. So in terms of Rule 23, I didn't have to simply enroll the exception. It was proper for me to inquire because they didn't have to file any subsequent pleading after you filed what you purport is an exception. Do you understand that?
I appreciate that. I understand that, my lady.
Yeah. So in light of the Rule 30, I think it's proper to deal with that first. If it disposes of the exception, then that's it. And then if it doesn't, then I'll give directives regarding the conduct of the exception. Is that fine?
But that is fine, my lady. In the circumstances, I hear what your lady says.
Okay. Okay, Mr. Fouché, you may proceed.
Thank you, my lady. My lady, I know that the bundle has been uploaded onto case lines. I don't know
I've received it. I've received it. Thank you.
Thank you, my lady. And can I also just inquire whether your ladyship received our practice note?
I did. Thank you.
Thank you, my lady. My lady, basically what the applicants tell your ladyship is that the process that's been followed by Mr. Kajee is incorrect in terms of Uniform Rule 23.1. That is why we say it's an irregular step. And my lady, the first of all is that Rule 23 and an exception, and I see that is actually admitted in the now answering affidavit, is a pleading. An exception is a pleading. It should be signed by an advocate or an attorney with right of appearance. You cannot bring an exception on notice of motion together with an affidavit. As your ladyship already explained to Mr. Manilal, is that Rule 23 makes provision, therefore, you file, if it is a vague and embarrassing pleading, you file a Rule 23.1 notice requesting the party to withdraw the causes or to rectify the causes of complaint, which is set out on the grounds in terms of the Rule 23 notice. If there is no amendment, and that is basically the response that is referred to in Rule 23, if there's no amendment then of that pleading, then the next step is to file an exception. It's not a notice of motion together with an affidavit. It's an exception that's a pleading, and that pleading will then ask for one prayer, my lady, and that will be for the exception to be upheld. If the exception is then upheld, then the normal route is for the court or the tribunal in this instance to afford the non-excipient, the respondent in the exception, to amend its pleadings accordingly if it is so advised. It is not for a dismissal of that pleading. And that is what one of the steps that is incorrectly taken by Mr. Kajee. He's asking for a dismissal, my lady, on a notice of motion together with a founding affidavit. So that whole process is wrong. It's incorrect. It's irregular. But it goes further, my lady. What that notice of motion then does, it actually calls on the respondents to also file an affidavit. So it calls on the respondents to partake in this irregular process. And it asks of them to also file an irregular document, because there is no answering affidavit in an exception process, my lady, because it's not a notice of motion with affidavit, with answering affidavit, with a replying affidavit. That's not the process. So that is why it was a difficulty. And I know your ladyship alluded to that there's many interlocutory steps taken, and the main matter is basically dragging. But that is why the applicants in this application, the plaintiffs, decided that it cannot partake in the irregular proceedings. They have to bring this application for an irregular step, my lady. Otherwise, they would simply also go on the wrong path and file affidavit, which is not proper, my lady, in this instance, and it's irregular. As your ladyship correctly pointed out, after the exception, the next step is head of arguments. There are no space in Rule 23, Uniform Rule 23.1 or 23 for exception proceedings for anything further to be filed, then heads of argument, and that's then been argued, my lady. So we say the whole process is irregular, my lady, and can simply not be entertained, and therefore that exception ought to be, or that notice of motion together with a founding affidavit ought to be struck as an irregular step, my lady. If I can then move, my lady, to just answer towards the points raised in the answering affidavit of the respondent. My lady, I see there's various points in limine raised. The first is that the plaintiffs or the applicants in the irregular step proceedings did not follow Uniform Rule 6 sub 5 A and B. But my lady, that is an incorrect argument, because we know this is an interlocutory application. In terms of Rule 30, an irregular step process. So you do not file a notice of motion in the long form in terms of 2A, Form 2A of the Uniform Rules of Court. You file a short notice of motion, an interlocutory notice of motion. In the Uniform Rules of Court, it's dealt with in Rule 6 sub 11, and in the tribunal rules, my lady, it's dealt with in Rule 10 sub 10, where it says, notwithstanding the foregoing sub-rules, interlocutory and other applications incidental to pending proceedings, which this irregular step application clearly is, may be brought on notice, supported by such affidavits as may be necessary, and set down at a time assigned by registrar or directed by the president of the tribunal or the presiding member. So it reads similar to Rule 611 for interlocutory applications. So there's nothing sinister there about, my lady, to file a short form without a new address being set out in terms of, as is requested in terms of Rule 6.5 A and B, without indicating to a party that he's got a certain time period to file a notice of intention to oppose or to file opposing papers, because it's interlocutory. The short form, my lady, as is set out in the Uniform Rules of Court, my lady, is in fact quite clear of that. And that is Form, I think it's 2B. I'm just getting to that, my lady. In the Uniform Rules of Court, Form 2A is the long notice of motion. Form 2 is the short form. Form 2A is the long form. So Form 2 in Superior Court Practice of Erasmus, your ladyship will find it at page D1-802, is simply stating exactly what has been stated in the short form used by the applicants in the Rule 30 application. So the form used, the short form, without indicating dates for opposing papers or a notice of intention to oppose, is 100% correct in terms of the Uniform Rules of Court form that is prescribed for a short form notice of motion. What is concerning, my lady, is that Mr. Kajee is an advocate of many, many years standing, that he raises a point like that. That is concerning, my lady, and it's clearly that he is playing for time and is not playing according to the rules. He's complaining, my lady, that he wasn't afforded an opportunity or a time frame in which to oppose or he says, audi alteram partem, he wasn't even invited to oppose, yet he files answering papers. He knows what the answer is, my lady. Mr. Kajee, the respondent in this matter, is an advocate who knows the short form. He knows what it looks like. He knows that you don't put in those kind of dates. And he files an answering affidavit. If he really did not know what to do, there still would not be an answering affidavit before your ladyship. And with respect, his attorney would also not be on the platform. So what he's telling your ladyship is not correct and is disingenuous from an advocate to attempt even to take a point in limine such as that, my lady. So the first point in limine, there's no merit in it. The rules provide for the short form, and clearly the irregular step is an interlocutory application. The second point...
Just before you move on, Mr. Foshier.
Yes, ma'am.
Right. given your submission that for a short form of a notice of motion, you didn't need to indicate time frames for opposing. Similarly, you could just pitch up at the day of, you could just file documents as they did. Because remember, an interlocutory rule 11, a 6 sub 11 type of interview. It is set down on Thursday for hearing on Tuesday. Right. So what would happen under normal circumstances is that a party who wishes to oppose could oppose in that time.
Correct.
So between Thursday and Tuesday, they could file their opposing papers.
Correct.
And therefore, he's not non-suited because here there was a time lapse because you applied for a date of hearing on the 31st of January.
Yes, something like that. Yes.
So it's not non-suited, and hence you appropriately didn't insist that I proceed with this application on an unopposed basis, right?
As your ladyship please. Yeah. Yes, my lady. Yeah. So by all means, there are, and the practice is also, because there's no time frame, an answering affidavit should be filed within a reasonable time, my lady. So,
and it doesn't have to be filed. You could have just come to court and dealt with the legal point, because this is all about procedure, really. It's 100%. All about procedure. Yeah.
100%, my lady. Yes, and especially, he's not a layman, my lady. If there's a layman raising these points, then maybe one has to look at it. But there's an advocate with attorneys. With all due respect, my lady, these points should not fly in a tribunal like this. If I can then step on to the second point, my lady.
Yes.
The second point in limine is that the applicant's Rule 31 application is materially defective as it does not comply with the rules for conduct in proceedings. So now it says it's using now the same wording as is used in the Tribunal Rule 10 sub 1, my lady. But that is the wrong form. It says now the notice of motion must appoint a postal or email or a physical address, must set out a day not less than 5 days to deliver the position, and point an address 15 kilometers from the office. But that will not be appropriate in the circumstances, my lady.
Yeah, but all that information is already...
Exactly, my lady. So
it's interlocutory. All that information is already before the tribunal.
Exactly, my lady. So to even attempt to raise that, I submit, is vexatious and frivolous, my lady. His third point is referring to Tribunal Rule 10 sub 10, which I now already read to your ladyship, and that is also, it's referring to interlocutory applications on the short form. So he's very well aware that there's an interlocutory manner or a manner in which to bring an interlocutory application before this tribunal in terms of the tribunal rules, and he raises the applicant's content that the respondents committed an irregular step by requiring the applicants to comply with this exception by way of an application rather than a notice. I'm not sure I understand the third point in limine, my lady, because the objection raised by the applicants in the irregular step proceedings is that Mr. Kajee did not follow Rule 23, did not follow exception proceedings, and he followed notice of motion proceedings. So I don't understand his arguing in terms of the third point in limine, my lady, because that was not our objection. What this makes clear is that Mr. Kajee is well aware of the interlocutory fashion in which it can be brought under Rule 10 sub 10 in this tribunal, my lady. So if I do understand this incorrectly, I would ask your ladyship just to afford me an opportunity in reply to answer to Mr. Manilal if I do not understand that correctly, with the leave of your ladyship, obviously.
That's fine.
Thank you, my lady. Then the fourth point in limine is a constitutional point that's been raised. And he says that in respect of the Rule 23.1, the exception application, he says that on 12 November 2022, the respondent had, in terms of Rule 10 sub 10, served upon the applicants a notice of motion with an affidavit as is required. But is incorrect, my lady, because his application in terms of Rule 23 should have been brought by way of exception proceedings, by way of Rule 23, not by Tribunal Rule 10 sub 10. But I'm just attempting to see his application that should be in the bundle.
I think it's from page 66.
Thank you, my lady. I appreciate that. That is the notice in terms of 23.1. I just want to see his actual application, the notice of motion that was sent. It should be before that, my lady. I apologize. Notice of motion, that's at page
18.
Page 18.
Yes.
So he says that he's bringing that application in terms of Tribunal Rule 10 sub 10, but that's not correct, my lady. He used the long form and he used the uniform rules of court. He's referring to Rule 65B and 651. He's not referring to Rule 10 sub 10 as an interlocutory application. He brought a long notice of motion, the long form of the notice of motion, rather than to bring an exception, which is a pleading. That is the whole complaint. So he's not even correct in saying he brought it under 10 sub 10 of the uniform rules. He said the applicant was to file an intention to oppose and thereafter file an answering affidavit. But that's incorrect, my lady. I'm not gonna point that out in being regurgitative, my lady, because we already argued to your ladyship what the process is, and your ladyship explained it already to Mr. Manilal. So his point in terms of point D, the fourth point in limine, is simply incorrect because he's not following the correct procedure, and his stubbornness about this is just clear in this argument, my lady. The fifth point in limine, my lady, is the audi alteram partem, where he says the rules of natural justice and a right to legitimate expectations should be addressed here. And he says the notice of motion did not inform the respondents of his right to oppose or file an answering affidavit. But, my lady, with respect, we canvassed that already. He is an advocate. It is an interlocutory application. He is now before the court, and he filed an answering affidavit. So his complaint in respect of this basically falls away and cannot be as seen as an opposition or a successful opposition in any event to the irregular step process that's been taken. Those are the points in limine, my lady. Not one of them, with respect, should be upheld. All of them ought to be dismissed with costs, and I submit it should be dismissed with costs on a punitive scale, including cost of 2 counsel. Your ladyship will see that I see Mr. Joubert is on the platform present at the moment, but as the junior, I'm just tasked to argue the interlocutory matter. My lady, and his answers in respect, just more of the same. He says the application is bad in law, it wasn't brought on the correct procedures. With respect, it's misplaced, my lady. The applicants followed Rule 31. They followed the interlocutory rule, how to bring this application. And there's absolutely nothing wrong with the manner and the fashion in which it was brought, my lady. So, with all due respect, I submit, and it's our submission, that the notice of motion with the founding affidavit in the supposed Rule 23 application ought to be struck as being an irregular step with cost of 2 counsel on a punitive scale, my lady. I see your ladyship is frozen on my screen. I don't know whether it's only the video.
Sorry, I had lost connection.
I saw your ladyship.
Yeah, I'm back. I think you were concluding, right?
I was, my lady. I took your ladyship. There's no opposition really in his ad seriatim answers to the papers. Our submission is that the application, or that notice of motion and the founding affidavit purporting to be an exception ought to be struck as an irregular step, and we submit that Mr. Kajee should be ordered to pay the costs on a punitive scale, my lady, including cost of 2 counsel. I've pointed.
So really, the substance of your case, which led to the demanding of an answering affidavit from you, and the call for the dismissal of the action is inappropriate.
That's correct, my lady. I've followed half of your ladyship. Your ladyship unfortunately went away a bit, but the process.
Let me come back. So I'm dealing with the substance of your complaint, not the procedural details, not the procedural nitty-gritties. The substance of your complaint is that the filing of a notice of motion supported by affidavit to bring an exception and the demanding of an answer is unprocedural because it's not provided for in Rule 23, Uniform Rule 23. And then you're also saying the call for the dismissal of the action is also inappropriate because it's not the relief envisaged in Rule 23, where the complaint is that the pleading is vague and embarrassing, right?
That is a gist, yes, and it should be a pleading, yes, my lady.
Yes. Thank you. Mr. Manila?
Thank you, my lady.
Thank you, my lady. My lady, I hear what your ladyship has stated in respect of Rule 23 notice, that it is a process of in the circumstances, Rule 23 notice was brought before the court, and the respondent, in his wisdom, decided that the way to proceed with the in respect of the Rule 23 notice would be to bring an application by way of notice of motion, supported by an affidavit. My lady, with respect, I submit that as much as this is part of what is required in terms of the Rule 23-1 notice is in terms of the uniform rules of court, with respect of submission, my lady, is that in certain divisions of the High Court, one can bring an application supported by an affidavit, a notice of motion and an affidavit. That I with respect submit, although I don't have the authority offhand, that this is a practice in the Cape Town High Court. However, as I indicated, I hear what your ladyship has stated in respect of the Rule 23.
You will need to support your submissions with authority. If you want me to consider, if you want me to uphold your argument that the procedure that you followed is correct, you must back it up with authority.
Yes, I hear what your ladyship has stated. I unfortunately don't have that authority as we speak. And I also hear what the counsel for the applicant stated with regard to the answering affidavit to the irregular step application is concerned. I take the point, my lady, that this was brought on the short form. And in those circumstances, the points that were raised in limine with regard to the notice ought not to have been raised.
So there are points you are conceding. You need to specify them so that then I don't have to deal with them.
In respect of the first point in limine, that is the uniform Rule 6.5 and 6B.
So you are conceding the first point in limine.
First and the second point. But insofar as the point relating to Rule 10.10.
Your sound has become bad.
Can your ladyship hear me now?
Thank you. Much better.
Thank you. My lady, insofar as the point in limine relating to Rule 10, paragraph brackets 10.
No, please mention the number of the point in limine for ease of reference.
Point in limine.
Okay.
With regards to the application itself, my respectful submission is that the tribunal rules does indicate that one can bring this a point with regards to non-compliance with Rule 1010 of the Tribunal Rules. Those are my submissions, my lady, in respect of the next point in the minute, the fourth point in the minute. I concede that, my lady. I otherwise leave the matter then in the hands of the court.
Is there a fifth point?
That point is also conceded, my lady.
So I didn't print the paper, so I don't want to be moving between devices. There is a fifth point, right?
Yes, my lady.
Which forces me to go. Yes. What are you going to deal with it, or are you conceding it?
Conceded.
You're conceding it. Okay, so that what really is left of your opposition is the third point. That's all that I need to deal with. Okay.
That is great.
Thank you. Reply.
Thank you, my lady. Well, in conceding 4 of the 5 points in limine, that underlines our submission that this opposition is vexatious and frivolous, and the Rule 23 application was also vexatious and frivolous, my lady. So there's no real point. The third point, I still, that's the point that I do not understand. It's the only point that remains alive is the third point in limine. Respondent was within its rights in terms of tribunal to adopt the procedure. It still continues with the argument that it was entitled to bring the exception in terms of a notice of motion, although he says it's in terms of the short form. He brought it on the long form. That's incorrect, my lady. It's an exception. Mr. Manilal says it might be a practice in the Durban division, or in the
Is it the Cape?
In the Cape. Sorry, my lady. But I'm certainly not aware thereof. He did not refer your ladyship to authority. And what is more, Mr. Kajee was practicing in Johannesburg, my lady. So he's raising a point as if it is the practice over here, being an advocate that practiced in Johannesburg, but raising something in Cape Town that might or might not be the practice there without any authority. I submit that on strength of that is not sufficient to be successful in the opposition to the irregular step application. And unless there's anything else.
Nothing further.
Thank you, madam.
Nothing further. Mr. Manilal, I believe that you are in Durban today. You are participating in these proceedings from Durban. Is that where you practice?
That is correct, madam.
You practice in Durban?
That is correct.
Okay. Thank you very much. Judgment is reserved.
As your ladyship pleases, madam.
The proceedings are adjourned.
As good.